Hello everyone, welcome to another episode of Talking Legal with Templars. I'm Chibuike Ikefuna. I'm an associate in Templars Tax Practice Group. I have here with me today Konyin Osipitan.
Hi Chibuike, thanks for having me. Nice to be here.
Welcome. And today we'll be discussing the Withholding Tax Regulations 2024 and the implementation guidelines issued by the Federal Inland Revenue Service, that's the FIRS. So Konyin, in 2024 October, the Minister of Finance issued the Withholding Tax Regulations 2024, and the regulations became effective in January 2025. What has changed between the new regime and the old regime of the withholding tax?
Thank you for that question, Chibuike. But before we move on to what has changed, I think for the benefit of our viewers who are not lawyers, it is necessary to tell them what withholding tax is.
Okay.
Now, withholding tax, as the name implies, might seem like a form of tax, but it's not. It's just an advance payment of tax, which just helps the government to curb people who want to evade paying their taxes and helps the government to get some more money ahead of time. Now, regarding the key changes that have happened in this new regulation, the first thing that comes to mind is that there has been a change in the deduction rates. In some cases, the deduction rates have been reduced, and in other cases, they've been increased. One case where it has been increased is in the payment of directors' fees. Under the old regulations, it used to be directors' fees payable at 10%, but with the new regulations, it has been increased to 15%. So that's one change on one hand. Another change is that a small company no longer has to deduct or remit WHT if the vendor that they're paying is already registered with a tax identification number and the amount that is being paid is less than 2 million naira. Another change that comes to mind is that under the new regime, there are a few transactions that are exempted from the obligation to deduct and remit withholding tax. One of which is in a case where a manufacturer supplies goods or products which they have manufactured. And the last change that comes to mind for me is the change in the penalty regime, where under the new regime, if you fail to deduct and remit withholding tax, you are liable to pay an administrative penalty, unlike in a situation where you actually deduct and fail to remit. In such situations, you'll be liable for the full 10% of the withholding tax amount.
Thank you very much for that response. Another relevant point with the Withholding Tax Regulation 2024 is the obligations of non-resident persons who have no taxable presence in Nigeria. It's not clear what the obligations are. What are your thoughts?
To begin, I think it's important to look at what was obtainable before. Now, in the previous regime, the obligation to deduct and remit withholding tax only applied to non-resident entities who had a taxable presence in Nigeria. Now, the wording of the current guidelines and the way that it's framed, in my opinion, leaves room for ambiguity and a lack of clarity regarding whether non-resident entities who don't have a taxable presence in Nigeria are required to deduct and remit withholding tax. If indeed the wording of the guidelines is interpreted to mean that non-resident entities without a taxable presence in Nigeria are required to deduct and remit withholding tax, we might have a practicability of enforcement issue at play here. And this is because of the lack of regulatory and monitoring purview of the tax authorities on those non-resident entities who don't have a taxable presence in Nigeria. In any case, it would be very prudent for non-resident entities without a taxable presence in Nigeria to seek legal advice in the first instance and also engage with the tax authorities for further clarity on this issue.
Thank you very much, Konyin, for that helpful insight, especially for non-resident companies who have no taxable presence in Nigeria.
You're welcome, Chibuike. Now, still on non-resident entities, Chibuike, I have a question for you. Now, how do you think the higher rates imposed by the new regulations will affect non-resident entities from treaty countries?
Although the withholding tax regulations provide that the rates prescribed in the treaties should apply to non-resident entities from those treaty countries, it doesn't quite address the issues that may arise from the disparity in rates. And that is because in some cases, the treaties allocate taxing rights to the source countries from where the income was derived. In this case, the withholding tax regulations for Nigeria, right? So take for instance, directors' fees. Most of Nigeria's double taxation treaties provides that in relation to directors' fees, the source country where the fees are derived from should have taxing rights. And what that means is that the withholding tax regulation would have to apply. Now, the same withholding tax regulation says for resident directors, 15% withholding tax rate, but for non-resident directors, 20%. Now, the crucial aspect of double taxation treaties are their non-discrimination provisions. Now, the non-discrimination provisions essentially provide that residents or nationals of a contracting state, right, should not be subjected to more burdensome tax requirements than local taxpayers in similar circumstances. Now, where there's a disparity in rates, or where a higher rate is imposed from an enterprise in a treaty country, it could potentially lead to a breach of those non-discrimination provisions, because the non-resident can argue that it is in the same or similar circumstance with the local taxpayer, but it's been required to pay higher taxes than the local taxpayer. So it could lead to claims for compensation or relief by non-resident entities coming from treaty countries.
Thank you very much for that. So what would your advice be for non-resident entities in that situation?
So there are a number of options available to non-resident entities from treaty countries, one of which would be the mutual agreement procedure under the double taxation treaties. So the treaties have a dispute resolution mechanism. Under that mechanism, an aggrieved party can present his case to the relevant competent authority. With respect to non-discrimination cases that is based on nationality, the treaties normally provide that such cases should be presented to the competent authority of the country where the person is a national. Right? Another option open to such persons would be to request an advance tax ruling from the FIRS, asking for clarity, right? Asking for interpretation of the non-discrimination provisions vis-a-vis the higher rates prescribed in the withholding tax regulations. Now, the outcome of that advance tax ruling can lead to, say, a challenge at the tax appeal tribunal all the way up to the Supreme Court. Another option is where the FIRS issues an assessment to collect the higher rates imposed by the withholding tax regulations to a non-resident entity coming from a treaty country. That entity could approach the tax appeal tribunal to challenge the assessment based on non-discrimination grounds in the tax treaty. But in every case, it would be prudent to seek legal advice.
Thank you very much, Chibuike, for that answer. And that was a very insightful response.
Thank you very much, Konyin. Thank you for joining me. I'm sure this has been a very insightful episode for our viewers. Until next time on Talking Legal with Templars, bye for now.